Welcome to Stop My Crisis. I'm your host, Vivian Gaspar. Have you been divorced? I'm sure you have friends who have been. And how many times has something come up after a divorce and you think you could just handle it yourself, or you don't know what to do and you reach out for an attorney? I'm very fortunate to have with us here today Sara Sencer McArdle, a family law and criminal defense attorney whose office is in Parsippany, New Jersey. Sara has been an attorney over 30 years, having practiced family law for over 16. She has successfully represented her clients in divorce cases, in child custody matters, support issues, and post-judgment motions, which have been filed after divorce has occurred. Sara, thank you so much for coming in and answering our audience's burning questions, because unfortunately, so many people keep going through this over and over again. So I've got to ask, what has happened the most that stands out in your mind with why would someone need help with an attorney after they get divorced? People always think of an attorney when they're preparing to get divorced.
Well, often issues arise during post-judgment with regard to support, with regard to alimony, with regard to child support, with regard to has the other party done what they should have done? Has somebody lost their job and can no longer pay the support that was necessary as per the property settlement agreement? Are the children going to college? Who's going to pay for college? Camp, who's going to pay for camp? What is going on 10, 5, 3 years later after the marital settlement has been signed? And that causes people to go back to court.
You mentioned camp. I think so many people think of camp as a luxury, not a necessity. Is that true? I mean, I would just think that camp, having been as I'm a parent myself, the person who has the custody of the children, the parent of primary residence, they've got to be able to work just like the person who pays the child support works. And so why should they be hindered? So isn't camp more of a necessity, not a luxury for children?
Well, probably 30 years ago, it was a luxury. Parents sent their children away to camp over the summer, and mothers were home, and they weren't working, at least many of them, not all of them, were home and weren't working, and therefore, why would the child need to go to camp? In this day and age, moms work, at least a majority of the mothers seem to work. There are many, many single family homes in America at this point. I think there are more single family homes than married family homes. And therefore, with a mother working or a father working, whoever's the parent of primary residence, and it can be either, they need camp. Summer is like a loosey-goosey time for kids. Yeah. And it's a difficult time for parents because there are much more expenses during the summer than there are during the school year. And if a parent has to work and the child is no longer on a schedule like they are in school, it's very difficult. And often sleepaway camp is the answer so that the child is entertained while the parent still needs to go to work every day and make a living.
Because after all, I mean, nobody sticks a 9, 10, 11, 12-year-old at the babysitter all day. I mean, that just doesn't work.
No, it does not.
So camp is the answer, but it's not a luxury any longer is my point. So does that get paid through regular, reoccurring weekly child support, or is that above and beyond? Because I imagine, unfortunately, I've heard this too many times, and it happens in everyone who's divorced lives, the parent who pays out of pocket or through probation or garnished from their paycheck, they're sitting there thinking, wow, I'm forking over money to my ex, and my ex keeps getting this money, and they get infuriated by it. When really, it's child support, not even spousal support. I read that over $1.5 billion is in owed child support. So obviously, not all the monies that are owed are even being paid.
You've asked a multitude of questions there. Let's take them as best as I can, one at a time. The first question is camp outside the guidelines or within the guidelines? Often, I will add camp to the guidelines and add them as an ongoing expense that needs to be paid weekly so that it doesn't creep up during the summertime.
Oh, so that's above and beyond child support, the base child support.
Well, child support includes medical expenses and work-related daycare expenses. So at some point, and often in a case, if we know that camp is going to be part of the equation, we'll add it to the child support guidelines.
So, but doesn't regular, weekly, reoccurring child support also account for housing and food and clothes and, the normal day-to-day stuff?
Yes, but you specifically asked about camp.
Right, of course. Because I know parents who have to pay out, they're like, well, why should I pay for that? Shouldn't that come out of normal child support expense?
Well, child support expenses are very specific. They are medical expenses, they are work-related daycare, they are food, clothing, shelter, they are clothing, I think I said that, food, clothing, and shelter. They are some sports, some extracurricular activities. So these are added into the guidelines. But if you have expenses that you know are reoccurring, for example, a child who's ill and has extra medical expenses, or camp where both parties say this child is going to camp in the summer because I can't be available. Those are expenses that can be added to the guidelines.
So you just brought up a good point before. You had mentioned about how child support includes medical expenses. Well, nowadays, unfortunately, it's really expensive. So if you don't work for a larger corporation that absorbs your monthly premiums, and perhaps you're a small business owner or 1099 contractor or whatever it is, it can get really expensive for health insurance. Who's obligated to pay health insurance, and is that covered out of child support? Health insurance could be a couple $1,000 a month nowadays.
Health insurance is covered in the guidelines. And if the parents don't have the luxury that we used to have 30 years ago of having our employers pay for it, whatever the child's share is divided by the parents pro rata their earnings.
So you're saying that the regular dollar amount that's mandated to be paid for child support includes the health insurance?
Yes, and that will be a figure that may change. And that will be a figure that's contemplated in the guidelines, except that the person receiving the support has to pay the first $250 of unreimbursed medical expenses.
Is that always across the board, or is that going to change per family's income level?
It depends if there's support being paid. If child support is being paid, $250 is included in the guidelines per child.
Per child, I see.
Per child, yeah.
Okay, that's a huge difference. What about when the parents aren't agreeing on what the expenses could be? So, for example, we were talking about camp a second ago. Obviously, day camp, where a parent drops off and picks up a child, is a lot less than a sleepaway camp.
Depends on the day camp, and it depends on the sleepaway camp.
Generally speaking, because, overnight expenses. But what if the parents don't agree on it? And unfortunately, what if that disagreement is, rooted in finances? The non-custodial parents like, well, why should I pay that much? That's your choice to send them to that camp. What do you do? Is that a reason to go back to court?
Well, let's understand that post-judgment motions are very expensive. And the courts will enforce whatever is in the marital settlement agreement. And a lot of times it depends on the facts of the case. Will a court make a call? Yes. Will the court decide what's in the best interest of children? It seems always that's what's important to the courts, is the best interest of the children. But are they going to give the parent of primary residence a carte blanche to do whatever they want? No. They're going to look at the incomes of the parties and decide what's appropriate.
So does that follow the same suit if we go a few years older for children and go to now their college years, their older teen years, they're 16, 17, 18 years old, maybe even upper levels of high school? So for example, we're talking about expenses. So what about when that wonderful teenager now drives? What happens? Who's responsible for paying for car insurance, which gets to be very expensive? We all know, unfortunately, boys are more expensive than girls for car insurance, but young girls are also costly. Who's obligated to pay for that?
That's one for the electro-thinker, because that comes out in all different areas, in all different courts. It really depends on the court. It's a very gray area of the law, because transportation expenses, according to the guidelines, are to be borne by the person who is receiving the child support. but that's not really a transportation expense. So that goes all kinds of different ways. And often the courts will say the child has to pay for their insurance and the child may have to pay for their own car.
So what if they're now, for example, okay, we know what happens in high school. Somehow there's usually busing provided or other means because they got to high school when they are 15 years old. How do they get to their school when they're 17 years old, a freshman versus a senior? Granted. But what about when that child needs to then go to college?
If a child is going to commute to college and not go overnight somewhere, I think generally courts would decide that that's a cost of the college education, that the supporting spouse is getting a break by the child not moving away from home. And I think in that case, a car might well be contemplated by the court to be divided, the cost of the car.
Because of course, I mean, that might sound like a minor thing, but car insurance nowadays, wow, it could be very expensive. If someone's only getting a few $100s a week in support, and car insurance could be, you know, maybe even a couple $1,000s, depends on if it's male or female, because that's just the way it goes. So then we're going into college realm. What happens when parents are disagreeing? The two parents have a total different idea on where the child should go to college, the type of college. Should they go to a county college first and then transfer because they think that's the cheaper way to go? Perhaps the child didn't get the best grades in high school, so now they're not qualified perhaps for the best types of scholarships. How do you settle that disagreement?
I think this is an area that people go to court for all the time. College expenses are a really big issue because if you're married, the child doesn't get to say, I'm going to go to college and you're going to pay for it, mom and dad. Or one of the parents doesn't get to say, you're going to pay for college, husband. The married couples, the courts are not going to get involved. And it's very case sensitive. What is the father's background? Is the father a stockbroker on Wall Street? Is the father a teacher? Did he go to college? Or was the father, for example, a truck driver? Or is the mother a waitress in a restaurant?
What is the impact? Now you bring this point up, it makes me very curious. What impact does it have? Because if this child has the ambition to go to college when their parents did not, I don't think should that hinder the ability for the child to go to college?
It doesn't hinder the ability, but the courts will look to the background of the parents. They'll look to the economic viability of the parents' ability to pay. They'll look to the child's grades in high school, as you mentioned, whether the child has shown an aptitude for learning, whether or not a child has resources independent of the parents, such as they'll be required to take out scholarships, loans, grants, but does the child have, for example, a trust fund? Or
well,
inherited
they don't,
funds.
because then it's not an issue if they had a trust fund.
Well, it still might be an issue because the parent might say, and I've heard it be said, well, why should the child's trust fund be used for education? Why shouldn't that trust fund be used for a wedding? He makes a lot of money, or she makes a lot of money. She works on Wall Street. Last year, she made $500,000. Why should the child use their trust fund for college when they'll need it later on in life?
Wow. To me, it just seemed obvious. Trust fund, there's the money for what you needed for college.
It's going to depend on many, many factors, and it's a case-by-case analysis. And it's very hard in these cases to predict what a judge is going to do. The judge is going to look at the best interests of the child and the economic feasibility of the parents of being able to pay.
So it leads me to another question. So let's say they're on the hook for, is it only for a standard four-year diploma, like a bachelor's? But what if this child's ambitions includes getting a master's or a doctorate? Does that mean they're cut off after, a certain amount of time?
I think the rule of thumb generally, unless we're talking about a very high-income family, is the child gets 4 years of education and for a college education. And after that, if you want to go to grad school, have at it. Go to grad school, but the parents aren't obligated. In fact, in this state, and I know this isn't just this state, but in this state, college is something that the courts are imposing that parents pay for if they're divorced. In other states, children don't get a college education.
Really?
No.
What is the majority? Do you have a feel for
Yes,
how
the
many-
majority is children do not get a college education
Wow.
from their parents who are divorced. New
amazing.
Jersey is a minority state.
Wow, that's really important information. The problem is a parent tries to do this on their own. Let's say that they got divorced when the children are young, maybe under 10. And now that they're getting into high school and now they're looking at colleges, this becomes an issue where maybe they just didn't think of it when they were getting divorced. And they really need expertise of a lawyer because they go to court by themselves. I mean, how well does that work out?
Depends. And another factor to be considered is what is the child's relationship with the parent who's going to pay? For example, has that parent been involved in the decision-making process? And if that parent has not been involved in the decision-making process, is it fair to pick up the phone and say, okay, Dad, I've picked my college. I'm going to go to Harvard and you're going to pay $50,000 a year. If the parent has not been involved in that process, it really isn't fair to expect that parent to contribute. What will the courts do? The case-by-case analysis, you don't know until you get in the court. And the answer may differ depending on who the judges are.
Wow, so it's never across the board. We know what the answer is going to be, but it certainly has to be better than doing pro se, representing yourself if you have an attorney who's fighting it for you. I think you also get a lot more respect in court.
Well, that depends. That depends.
I know some people have tried to represent themselves in family court and it did not end well.
Representing yourself in family court is a very difficult situation. If we don't know how it's going to end up, how can somebody who hasn't been practicing in the family court arena know how something's going to end up?
And this is a very slippery slope for trying to do this themselves. Again, it's just, I don't see how it works out. And this is unfortunately why lawyers are needed, especially someone like yourself who's been doing this with so much knowledge and passion. But
I've seen people who file their own divorces and they think they're divorced, and because they did it themselves, they're not divorced.
how? But did they actually go up to court and they show up to court and they have a hearing in front of a judge and they're not divorced?
Right. Because they haven't followed through. They don't know what steps they need to take.
Well, couldn't they just ask the court, okay, I'm in front of a judge, what do I do next? And
The court is not really supposed to tell people what to do. The court is supposed to follow the law. People who are appearing pro se are presumed to be similar to lawyers.
wow. So that could be a slippery slope. You think you're divorced, you go to get remarried to someone else, and look, now you're accidental polygamist.
It's happened.
Really?
Although, bigamy used to be a capital crime or very serious. Now it's a disorderly person's offense and not
But still,
very
I don't
serious.
think your new spouse wants to hear that.
No, I don't think so.
That would be a good title. It's the accidental
The
polygamist.
accidental marriage.
Oh, no, that's I hope you never heard of that before. So what other types of post-divorce judgments occur? What motions do you frequently have filed?
I think the most is support. Somebody has agreed to pay $200 a week based on a job where he earned or she earned $50,000 a year. All of a sudden, the job disappears, and you don't have that money to pay anymore. Can you get a reduction in the amount of alimony and or child support? That is the most frequent type of motion.
The reduction.
The reduction, yeah. And the courts have a duty, they're duty bound to follow the marital settlement agreements. So unless there's a substantial change in circumstances, the courts are going to follow the marital settlement agreement. So if you agreed 5 years ago to pay lifetime alimony to your spouse, and 5 years later you lose your job, you better show that there's an extreme change in circumstances, or you take a $50,000 pay cut. You better show that there's an extreme change in circumstances, or the supported spouse all of a sudden has gone to school and has a great job, and now she's making as much as the supporting spouse, or he's making as much as the supporting spouse. is it fair for that person to be getting the same amount of alimony or support and maybe making more than the person who's supporting her? So,
wait. What if we take a different approach? Here's my question that I think it happens a lot as well. I'm sure that does. But what about the people who are full of animosity, they're full of combativeness, and they're just annoyed because they always see, I'd like to stick to child support for a second, and they see it as always going to my ex, it's going to the adult, they're not going to the children, it's child support. But so many times, I'm sure you hear it's going to the parent, not the child. So what I want to ask you is, what about the person who's supposed to pay, the non-custodial parent, deliberately either not working or getting jobs that are substantially less than they had maybe had for 20 years just to have to pay less or no child support at all? Does that happen?
well, I'm sure it happens, but it's kind of a self-defeating thing to do, to shoot yourself in the foot. And so not to pay child support. Child support isn't that great a part of your income that you should purposely, make less money. However, one thing that sticks in people's craws, let's say the woman is paying child support, and her perception is she's handing all this money over to this guy to support the children. What people don't realize is those child support guidelines have two columns. One is for the supporting spouse, and one is for the supported spouse. And the supported spouse also has a child support obligation. No, they're not getting the money because that person is using the money that they make and the money that they're getting to support the child. So child support generally doesn't cover all of a child's needs. It doesn't cover the roof over their head. It doesn't cover the food in their bellies. It doesn't cover the clothes on their back. Child support doesn't cover everything. So people who complain about it, they really should look at the other column because both parents are contributing to the lifestyle of the child.
Unfortunately, I think that people who have this combativeness within them, they only see their perspective. I think that when they're looking at it, they don't know how, or they don't want to open their eyes to the other parent's perspective. So
that's our job. That's our job to say, look, you're paying X amount of dollars, but look at what she's paying. You're not paying the mortgage on this house anymore. You're not paying the clothes on this child's back, for the clothes on this child's back. You're not paying for the food in their bellies. You're not paying for their sports. You're not chauffeuring them everywhere around town. And I think if a lawyer sits down and talks to somebody and says, listen, you're going to pay $5,000 to go to court and litigate this case, and what are you going to get out of it? I mean, part of a lawyer's job is to say, it's not worth the fight. You're only paying $10,000 a year child support. The money belongs in your children's mouth, in your ex-wife's or ex-husband's pocket, not in my pocket. And that's part of what you do as a lawyer, is evaluate a case and say, yeah, this may be worth something or it may not be worth something, but you're going to pay a lot of money maybe to get nothing.
Thank you, Sara. It has been really eye-opening because now truths have come out, and I'm sure there's many other questions burning in the minds of our viewers, and that they could do is talk to you.
Thank you.
Or another really wonderfully qualified attorney. But that is what you have to do to stop your crisis, to stop your suffering. Do what you need to do. Find the way to get the help for your family through a great attorney and stop your crisis.